With today's event. This afternoon, I have the privilege of introducing this next panel of experts, which will discuss AI as it relates to criminal justice. With us today, first and foremost, I have Jessica Eaglin, and Trina mentioned this morning, Jessica was one of the kind of masterminds, if you will, bringing us together for the symposium. She was also a part of the first panel. Chaz was also another one, mastermind, if you will. But they're all experts in their own right. Jessica is also a Duke Law alum, so welcome back, welcome home. She's a professor of law at Cornell Law School. Her research examines the expansion of technical legal practices in criminal administration as response to the economic and social pressures of mass incarceration. She's a leading expert on algorithms in criminal sentencing. Her articles and essays have been published with the Cornell Law Review, Stanford Law Review, Washington University Law Review, among other journals. Professor Eaglin was counsel in the Justice Program at the Brennan Center at NYU School of Law, where she assisted with a national campaign aimed at addressing mass incarceration in the United States. Prior to that, she clerked on the Sixth Circuit with the Honorable Damon Keith on the Sixth Circuit Court of Appeals. She began her law career as a litigation associate at Simpson, Thacher, and Bartlett out of New York. We have Professor Chaz Arnett, Professor of Law, University of Maryland, Francis King Carey School of Law. Professor Arnett holds expertise in areas of criminal procedure, race and technology, juvenile law, and education law. His research explores the interplay between race, digital technologies, and criminal legal processes. Professor Arnett's most recent work focuses on examining the role that surveillance technologies play in perpetuating racial inequities through policing and corrections. He is an affiliate of the Center for Critical Race and Digital Studies and a faculty fellow at Data in Society. Prior to joining University of Maryland, he was an assistant professor of law at the University of Pittsburgh School of Law, where he was designated as the Distinguished Public Interest Professor for his commitment to furthering social justice in his teaching, scholarship, and service. Before that, he was a trial attorney with the public defender's offices in Baltimore and New Orleans, and a staff attorney with the Advancement Project. We have also with us Sarah Olson, Forensic Resource Counsel with the Office of Indigent Defense Services here in North Carolina. The office, attorneys litigating complex scientific evidence through its Forensic Research Resource Counsel. Attorney Olson works with the public defenders and private appointed counsel and improves counsel's ability to understand forensic science evidence and achieve better outcomes in their cases. Through individual case consultations, continuing legal education programs, Attorney Olson educates attorneys about relevant forensic science issues and assists with litigating claims related to forensic evidence at the trial, appellate, and post-conviction phases of representation. Prior to working as a forensic resource counsel, she was an assistant public defender here in Durham. After law school, she completed a fellowship with the Fair Trial Initiative, where she worked as a part of defense team representing clients in capital cases throughout North Carolina. She also has served as chair of the criminal defense section for the North Carolina Advocates for Justice, the co-chair for North Carolina Advocates for Justice Diversity and Inclusion Task Force, and co-chair for the Forensic Science Research Committee for the National Association of Criminal Defense Lawyers. And we also, last but not least, in terms of seating order, we have Professor Brandon Garrett, the L. Neil Williams Jr. Distinguished Professor of Law and Director of the Wilson Center for Science and Justice here at Duke University School of Law. Our very own Professor Garrett is a leading scholar in criminal justice outcomes, evidence, and constitutional rights, and is the inaugural distinguished professor, as already named. And he's the inaugural director for the Wilson Center, as already mentioned as well. And this, the Wilson Center is an initiative that brings together faculty and students to improve criminal justice outcomes. Professor Garrett's current research and interests focus on evidence, forensic science, constitutional rights, habeas corpus, corporate crime, and criminal law. He is the author of 6 books and that's not to mention articles, essays as well, so he's very prolific. Those books have been translated for editions in China, Spain, Japan, Korea, and Taiwan. In addition to those publications, he has been cited, widely cited on numerous courts, including the Supreme Court. He graduated from Yale University School of Law. He received from, Yale University undergrad. He received his Juris Doctorate from Columbia, where he was the articles editor for the Columbia Law Review and the Kent Scholar. After graduating from law school, he clerked with the Honorable Pierre N. Laval, the U.S. Court of Appeal for the Second Circuit, and worked as an associate before that in starting his career. So with that, ladies and gentlemen, please give your attention and a round of applause to this distinguished expert panel on criminal justice. Thank you.
All right, so thank you so much. It has been such a delight to participate in this panel, or to be participating in this panel, but in this entire gathering. It's been just so enlightening. I want to thank Gio, thank Trina, thank Margaret as well for the work that was done to get us here. I'm just going to start with just a brief word of framing our conversation before turning it over to the panelists for a robust discussion. So I'm really glad to be following up on Charlton because when I think about discussions around AI and criminal law and just AI in society, I am in whole agreement with his reference where he says, we can't just focus on the tools, right? There's a social, historical context in which these tools are being implemented. And I think that that's part of what makes thinking about AI in the context of criminal law so powerful, particularly when we're talking about marginalized groups. Because yes, as we've been discussing all day, there has been a proliferation of technologies in so many areas of our lives, and criminal law is no different. But in addition to and alongside the exact same moments that we see technology expanding, we also know that we live in the era of mass incarceration. The United States incarcerates 25% of the world's prison population, or is 25% of the world's prison population. We're only 5% of the population. But the point is to highlight that not only do we know we live in the era of mass incarceration and that the United States is an outlier in terms of its rate and its size of the incarcerated population, but we also live in this moment now where we're still dealing with the ramifications, or some would say sort of the end of a moment of racial reckoning around criminal law and criminal law's enforcement, right? Where we really have, as a country, had to look in the face of what our criminal justice system does and how it disproportionately impacts marginalized communities, Black and brown people of color most specifically, but marginalized communities along a variety of axes, and how to really acknowledge that. So what does it mean to think about the expansion of technology in a space where we are uniquely aware of the racial impact that the criminal justice system has? And so I'm so excited to be thinking about sort of this poignant and salient sort of convergence of technology and society with this esteemed panel. So thank you guys so much, and I will try to hold my questions so that everybody else gets a chance to think a little bit about what's going on as well. So let's begin the conversation with some specificity. We'll start with Brandon. So you recently published an article that provides a helpful overview of the places where AI is expanding in criminal law. And I wonder if you can just start us off with a few examples and a description, as you might sort of characterize it, of how the expansion of these technologies implicates marginalized communities.
Sure. So one difference which kind of came out in the conversations this morning, and this is such an incredible conference. Thank you again to Trina, to Gio, to Margaret and the other organizers for having us all here. And thank you all for coming to see us here at Duke Law School. So AI is in a collision with well-established constitutional rights in the criminal legal sphere, which makes it different than other contexts where there's relative freedom for AI developers to just try out their tools on consumers. And if it leads you astray with your Netflix movie recommendations or what you'd like to buy online, then the harms may be real, but not as concrete as when people are being deprived of liberty in the criminal legal system. And when we're not just thinking about an AI Bill of Rights, but there actually is a Bill of Rights and a 14th Amendment that protects people. And so, when we talk about, well, where will the vendors be held accountable? They both may do the most serious harm in the criminal legal setting, and they may actually get put out of business if they violate people's constitutional rights in this setting. So some examples that you all have heard of, and there are many more that are coming into the picture, sort of as things evolve. For many years, there have been software platforms used to evaluate complex DNA mixtures. There are two main providers. There's been litigation around the country in which defense lawyers have sought to get access to the software. Whether it's sort of since the providers don't want to provide that access, it's not clear to what degree those involve AI or just complicated algorithms. In the area of risk assessment, which Professor Eaglin has written wonderful pieces about. Similarly, there are some very simple algorithms. There are also more complicated systems which may involve AI, but if they are black box, we don't know. And risk assessments are used in a whole host of settings to decide whether people should be detained or not pre-trial for sentencing purposes. Most of those instruments are not AI; they're very simple, but some may be. There have been some pilots and some, more than just a pilot of predictive policing, where AI analysis is used to try to target law enforcement. And there has also been use of AI to generate other types of evidence. Just this summer, it was announced that one of the main body cam vendors said, here's this new feature that's just offered for free to law enforcement that will generate police reports using generative text from body cam video. And those of us in the AI and criminal legal space had thought, well, generative text is not going to be our problem because you don't make up data in real cases. You want to predict real things, like whether someone poses a real risk or whether a policing practice is helpful for public safety, involving real data, maybe biased data, maybe flawed data, but you want to at least try to rely on real data. You don't generate fake evidence for purposes in court. Well, now we have generative text available, at least, whether law enforcement takes it up, we will see. And there was a first-time decision this summer where software was used to enhance video in a case. And a judge ruled that since, was this generative? What did it do? A lot of pixels were generated in this video. I don't know whether to trust it. The judge excluded the expert that was offering to enhance the video so that the jury could get what he thought was a better picture of what happened at a shooting scene. So lots of different uses. Those are just a few that have grown in recent years, and there's a lot more to come and lots to talk about in terms of how do we evaluate these tools. What's the role of academics to evaluate these tools? What should responsible government agencies be doing before using these tools? Lots to talk about.
Thank you so much. So, Sarah, can you explain to us a little bit about how maybe some of these technologies or others that implicate AI pop up actually in the courtroom?
Sure. So when I think about these new forms of technology and how they're used in criminal cases, I often think about them kind of in two buckets. And one would be the group of technologies that uses AI or at least complex algorithms. And those would be, like Brandon mentioned, software that's used to interpret DNA mixtures, software that's used to compare firearms evidence, like projectiles from the crime scene to the firearm that the suspect possessed, and things like facial recognition technology. And then there's another bucket of technologies, and those would be the surveillance technologies. Things like drones, license plate readers, cell phone location evidence, app data, wearables, monitoring of and recording of all jail phone calls, body camera, shot spotter, I could keep going. And not all of these technologies involve AI, but they are sweeping up vast amounts of private data that are being fed into criminal prosecutions, which of course results in more convictions, and then increased surveillance of these marginalized communities, which in turn results in more prosecutions and more convictions, and then on the cycle goes. So my job at Indigent Defense Services is to work with any public defender or private appointed attorney in our state to help them quickly get up to speed on scientific evidence that's new to them, so that they don't have to reinvent the wheel each time that they're encountering a new type of evidence. Currently, I'm consulting on a case that involves purely this new type of evidence, this tech-based evidence. There was a surveillance video from a crime scene of a shooting. Shell casings were collected there, and then those shell casings were linked by a computer, analyzed by the computer, and then linked by a database to another crime. And then license plate readers were used to locate the suspects from that other incident. And then there's some facial recognition involved in that case as well.
Everything.
So like not a shred of traditional investigation. It's all this tech data that's being used in this case. And we know almost nothing about the reliability of any of those technologies that I just mentioned. And for every client that we represent, the client is low income. And in this particular case, it's a client from a marginalized community. They're represented by a public defender at state expense, and that representation gets more and more complex with the growth of these software-based technologies. And that client has a right to expert assistance. Our Supreme Court guarantees that they'll have the right to an expert to help the attorney prepare, evaluate, and present the evidence at trial. So in thinking about the case that I just talked about, like how many experts would that case involve? Like you would need a firearms expert to look at that firearms evidence, a software expert to look at those 3 different softwares that were used, to go through it, to look for potential errors in the code, to test the reliability of the software, and to look for bias that could be in the code. But before those experts can even look at the code, the attorney has to litigate access to the code, because all of those softwares are proprietary black box software. So you can see this case has become extremely complex. But this is what our attorneys are dealing with today in the courtroom. And so for the students who are here today, I want to encourage you that if you've been listening to the discussions today and asking yourselves, how can I get involved in this right now? And how can I be a part of the decisions that are being made, the challenges that are being made to the constitutionality of the technologies that we're talking about here? We need you in our public defender offices and on our court-appointed attorney list. Professors, please bring that information back to your students as well, because now is the time to shape our law on the admissibility of this evidence and to be a part of the development of that law.
Sarah, can I follow up and ask you, how did you find your way to this role?
So I was a public defender before I took on this position. I've been in this role for 14 years now. The role was created right after the 2009 NAS report. The National Academies of Sciences did a landmark report on looking at all of the different forensic fields, and had a number of critiques of each of those fields. And the director of Indigent Defense Services decided, it's not efficient or effective to have each attorney trying to get up to speed on this evidence on their own. So he wanted to centralize information, create like a clearinghouse of information so that we could get up to speed quickly. And it was just an incredibly interesting position to me. And so I was excited to take it on and learn about all these fields of forensic evidence. It's been
So do you have a background in science?
I do not. So
Okay, hear that, lawyers. We don't have to know the science already. Okay, you can just learn it.
yeah, I've learned a lot on the job, and also a lot of the science in these cases isn't very complex, and so it's been something that an attorney can take on.
Thank you. All right, so we're going to transition to Shaz in a moment, but I do want to go back to Brandon really quickly. So at this point, both Sarah and Brandon have referenced the black box. And I wonder if you could speak a little bit to So first, what do you mean when you say black box? But then more pointedly, what is the implication of black boxes when you're thinking about marginalized groups in particular?
So what we mean when we say that software is a black box, and by the way, this is an issue with old school traditional forensic experts as well. So if you have a fingerprint examiner looking at latent fingerprint and comparing it to a suspect print, they'll say, like, I can't tell you how many points I need to see. It's based on my training and experience that I decide that this is a source identification. The process is a black box. You're relying on that person's training and experience. They can't say, except loosely, what steps they follow, but ultimately their criteria for making that decision is it's based on their training experience. They are a black box. Now, you can test them and find out how accurate they are. That normally isn't done. But there's a concern that they can't exactly say what they did. There aren't like an objective series of steps that they can point to or measurements that they made. They can point to certain similarities, but that's where with software, you can have the same challenge where it's designed in a way, and it's an intentional choice, it's designed in a way, or the developer keeps it in a way where you don't know what it relied on. Just like that fingerprint examiner can say, I observe similarities, that's what I look for, but I can't tell you how I reached this conclusion. When you run expended shell casings from a crime scene, rather than show it to a human, if you run it in this database, the NIBIN, that relies on software. It may not be AI, it may be simpler, but whatever it is, it's relying on criteria to select candidate or just a single best match, depending on what you're doing with it. Same thing with facial recognition. It'll select candidates based on relationships and measurements in the faces. Now, it might be that the developer of the NIBIN or the facial recognition tool could tell you these are the criteria. We're mostly relying on like the distance between the nostrils and the pupils and the eyelashes and the ears, or these are the measurements that we most relied on to decide that this face was the most similar in the database. You could have a system which is interpretable where it tells you what it relied on and with what weight. It's a choice not to, but it's certainly easier just to, if you're a developer, just to let the machine do its thing and see what it comes up with, and then you don't have to put the work into defining it or knowing what factors it relies on. Or you could have something where you absolutely know what weights it gives and what it relied on for the software to make its prediction or to make its conclusion. You just don't want to share it because you don't want a competitor to copy what you think is a really good piece of software. The problem is when you are dealing with the rights of vulnerable people in court or the rights of any person in court. If you want to, from the perspective of a public defender that's talking to Sarah Olson about their case, if you want to know, if you want to be able to argue this system could have made an error in my client's case because it says my client is high risk, but my client, my sense is a lot of these things rely on age, and my client is actually 28 years old. That's out of the usual risk category. Did they get my client's age wrong? Because I can see in the criminal history here they got my client's age wrong. So maybe there's an error. To challenge an outright error, you can't really do that if you have no idea what the software did. And so that implicates a lot of different rights. Brady versus Maryland rights to challenge experts. Like, how do you challenge the expert if the expert says, well, I'm not actually an expert on this facial recognition system. I just kind of pressed go on it and ran the software, but I don't really know how it works. I can't tell you. That again raises a question about their confrontation rights and the rules of evidence, where evidence of sort of unknown reliability that you can't really appropriately challenge in court is being introduced. So there are lots of rights concerns with systems that are black box where it doesn't report what it relied on and with what weights. And you just can't speak to it. You can't challenge errors. You don't know how it works. And so that's a real concern for all of us in the legal community, because in court we actually do need to know how things work, and we need to be able to bring out the reliability, the strengths and the limits of that evidence for the fact finder.
Thank you. So at this point, we're sort of thinking about the sort of challenges and concerns that AI can pose in criminal process, particularly thinking about the trial. We've heard issues of reliability. We're hearing issues about constitutional rights. Chaz, your work really challenges us to think about sort of the issues that AI and technology can raise at a broader scale, broader context of technologies, broader context of its impact in society. So I guess my question to you is can you talk to us a bit about how AI impacts marginalized communities in ways that might further criminalization. How do we see that reflected in your work?
Thank you for the question, and thanks for the invite, for being here, and for everyone that pulled together this symposium. It's been fantastic, and thank you to everybody that did, work from getting us here to ordering the food to cleaning the bathrooms and preparing this room. So I've been thinking a lot about generative AI. In a forthcoming paper, I argue that there's a lot of hype around generative AI technology, and a lot of that hype comes from the selling of a promise, right? And that oftentimes that promise is utopian in nature, that generative AI will get us to achieve some utopia or some utopian-like ideals. I think connected to this notion that the capabilities will continue to advance and push humanity to limits that we've never seen, achieving our wildest imaginations. In this paper, I stress that not only do these utopian appeals obscure some of the most dangerous dystopian aspects of technology. I was just reading an article during the break before we started about how nuclear reactors are coming back online to be able to process all of the energy needs of companies like Microsoft in terms of AI, right? So dystopian aspects in terms of what the technology needs and does, the regressive logics undergirding it, and the troubling philosophies of its biggest proponents. But they also influence how we approach governance and regulation of these technologies, and as well in ways that leave Black and brown folk here and abroad particularly vulnerable to exploitation. And I'm gonna say a little bit more, but I wanna show some images because we'll be talking about generative AI here. So I see this vulnerability as intimately tied to the vulnerability that Anita Allen talks about and theorizes in her recent work on what she describes as the Black Opticon. In her paper, she argues that in our current digital age, large tech platforms based in the US collect, use, analyze, and share massive amounts of data about individuals motivated by profit and with limited transparency and accountability. She stresses that our inability and quite frankly, our disinterest, rather, to get a hold of these institutional failures comes at a price, a heavy price. And the social costs of that diminished information privacy include, she argues, misinformation, political manipulation, and racial discrimination. And she explains how Black people are particularly vulnerable in the context of diminished information privacy and inadequate data protection. Now, with this Black Opticon, she describes 3 forms of vulnerability. I won't go into deep detail on each of these, but she talks about the excessive discriminatory surveillance, the panopticon, and as she refers to. Second, targeted exclusion from differential access to online opportunities, which she refers to as the panopticon. And then third, the exploitative online financial fraud and deception, which she refers to as the opticon. And she gives examples of each. If you aren't familiar with the work, you should check it out, read it. It's really brilliant. But this gets me to my current project and thinking, where I want to expand upon Allen's framework here. And along those lines, I believe that there should be at least a 4th category. And I think that 4th category, of vulnerability should be one that centers on dignitary harms and dehumanization that manifests from the generation and promotion of racial tropes and stereotypes that lend themselves to efforts to maintain racial hierarchy and subordination. She had the clever descriptions. I'll call this one subopticon, right, for its lending to subordination. And I think this would recognize the work of those like Sophia Noble's work on algorithmic oppression and technological redlining, and Ruha Benjamin's work on the new Jim Code. I see this clearly in the context of generative AI and digital blackface. And I have a few quick examples, but before that I probably should say a bit about digital blackface and perhaps blackface itself and what I mean here, and tie it back to criminalization in this panel. Blackface, many of you know, has its origins in the 19th century. Minstrel shows in which primarily white performers don dark black face paint while engaging in song, dance, comedy routines, and improvs. Now, in these performances, black people were often portrayed as violent, unintelligent, sexually aggressive, drunkards, living simple-minded existence, yet always carefree and seemingly happy. The emphasis on the enslaved black person as perpetually content, smiling, and joyous in song and dance, in many ways echoed the forced entertainment on plantations where white slave masters would force those enslaved to dance and sing, particularly when they had guests visit the plantation. Now, this sort of fiend happiness, fiend contentment was a way to obscure the violence that was taking place in everyday plantation life. Sadia Hartman, in her work in Scenes of Subjection, linked blackface with other aspects of the antebellum era as well, where blacks were, again, forced to dance, sing, and fiend enjoyment as a way to obscure violence. Now, in recent years, people have talked about digital blackface as a concept, and in popular media, digital blackface has been generally discussed and used in the context where GIFs or memes with black people are frequently used by non-black people. And in instances on social media and other online platforms where people or bots masquerade as black people, either through the use of an image of a black person connected to an account and or the use of black slang terminology or the engaging in black discussions and topics. However, I think we can think about digital blackface generally as instances where digital technologies and platforms provide online opportunities for the caricaturing of black people and communities in ways I would argue is directly connected to and more in line with the dehumanizing legacy of the 19th century and early 20th century blackface. This form of blackface not only promotes black people as other, as subhuman, but also facilitates what Khalil Muhammad described as, the condemnation of blackness in the criminal context. Now, not to belabor this, I want to just give you all two quick examples. One in which Sonia Gibson Rankin, I think she left out, but in the first panel, she referred to this AI-generated rapper, by the name FN Mecca. This digitized rapper was designed by two non-black creators, Brandon Lee and Anthony Martinez, and voiced by a black rapper, Kyle the Hooligan. As you can see here, he's, fair skin in comparison, braids, gold chains, gold fronts, mohawk hairstyle, in addition to numerous tattoos. If you go, he has a TikTok, which has amassed, I think, over 10 million followers, has songs and the like. He exemplifies every racial trope you can think associated with black rap music, including an obsession with displays of wealth, glorification of violence and incarceration, exaggerated urban styles of dress, sexual objectification, of women, gratuitous use of racial slurs and the like. I mean, if you want to go and dive into what's on the TikTok, be warned. Even more, you can see up in the, I guess for you all, in the upper right-hand corner, there was a lot of criticism when, there was even a post about him being subjected to police brutality. Now, some of you may say, well, what does this have to do with blackface? Looks white. And I would say to you all to note that with blackface in the 19th century, nobody believed that the people that they were seeing were actually black in these minstrels shows. It was about the message being conveyed, and I believe here the message being conveyed is one about black culture, black hip hop culture, black youth culture, and the like. Last example I'll give you all here and try to tie it back to the aim of this panel. If you all watched or saw highlights from the presidential debate, you know that former President Trump echoed false stories out of Springfield, Ohio, that citizens of Haitian descent were eating pets, cats and dogs. Immediately in the wake of that, you saw the proliferation on social media and other online platforms of these AI-generated images, some of which people thought to be funny. I did not find humor in them. Many Haitians did not find humor in them. But these sorts of images not only signal black as threat, black as danger, black as criminal, black as savage and brute, they legitimate harsh carceral approaches and act to incite and invite violence towards black, be it police violence or vigilantism. And we've seen this most recently with bomb threats in Springfield, Ohio. So in concluding, I would just say this raises a number of questions, right? So one, how should criminal law litigators, advocates, scholars engage with and confront the AI practices outside of the criminal legal system that clearly have impacts on criminalization and carcerality? Also, how do these practices work hand in hand with AI technologies that are being used in policing and corrections, right? Because this is outside of the criminal legal context. Are they the same logics, policies, companies, institutions facilitating these opportunities? And then third, how or can our privacy law and policies respond to these dignitary harms? Do we need a more robust understanding of this concept, which I refer to as dignitary privacy, right? And how should that shape data regulation and protection? So I'll leave you all with that.
Thank you. So I appreciate this, sort of in terms of transitioning a bit from thinking about how do we describe what the problem is to beginning to think about how can we imagine law's role in addressing it. And so we're just going to go down the line and think a little bit about some of the ways that you see sort of law entering into and addressing the challenges that AI poses in criminal law with a focus on marginalized groups. So Brandon, we'll start with you, thinking a little bit about legislative and policy initiatives aimed to address the expansion of AI. What kind of initiatives are being implemented both in the United States and abroad that are particularly thinking about criminal law? And how do you see that potentially impacting the threats that it may pose for marginalized groups?
I think this is it's a really interesting question, really interesting topic. Because there's so many rights implicated, if people are going to be deprived of liberty, maybe even life, based on evidence gathered from surveillance or using AI, a lot of rights at stake. And so some of the most sort of publicized abuses of AI have been when it's led to false arrests, like using facial recognition and the like. It gets a lot of attention, obviously, when AI could lead an innocent person to be arrested, potentially charged with crimes. At the same time, we also know that there are lots of exceptions built into our law around law enforcement, all sorts of different law enforcement exceptions. So in the EU, the AI Act that they passed, which has yet to have regulations spelling out how it will function, There are ongoing debates about what remedies, if any, will there be for people, for example, charged with crimes, because any use of AI by law enforcement or in court is high risk under the AI Act, and so receives kind of the highest level regulation under that act. But whether there will be wholesale law enforcement exceptions or what remedies people will have, like you don't normally have exclusionary remedies in many continental systems, so can you exclude evidence if they violate the terms of the AI Act in Europe? We will see. In the US, there have been state laws passed regarding facial recognition technology, mostly loose limits, more sort of study commissions. We need to do an inventory of ways that AI is being used. There have been some recent efforts that have been a little bit more pointed, but not yet implemented, like within the federal agencies, guidance on procurement that agencies are supposed to be looking at, which could potentially impact law enforcement. One development, though, which may create opportunities to litigate these issues in court, not yet part of the law of North Carolina, but it may not have to be in states that haven't yet adopted it. Rule 702, the federal rule that regulates expert evidence, was amended last December for the first time in 20 plus years, with advisory committee notes emphasizing that judges haven't done adequate gatekeeping of the reliability of expert evidence. And this comes at a time when these new AI tools are coming into expert evidence, and it really raises a serious question about an expert's reliability if the expert can't even say how the tool works. And so I see that 702 revision coming at an important time when AI is, there's the potential for AI to be introduced in court. There are also a lot of ways that AI has already been kept out of court and out of criminal cases because of constitutional criminal procedure protections. Like there's a reason why law enforcement agencies use facial recognition to generate leads, but no one's bringing the person in to be a facial recognition expert in court before the jury. They know that they can't really defend that person as an expert because they don't know how the software works. It could be biased, it could be error prone. And so there have been some good ways that the existing protections have warded off problematic uses of AI. The last thing I'll say is that there is a role that we as scholars and researchers can play to evaluate uses of AI, which could drive legal reform or good decisions by government. Here at Duke, we've done a couple of different field studies, really, where we didn't have access to the AI model, but we could get administrative data to see how adopting this model affected outcomes in real cases. The most recent one was an evaluation that Phil Cook led here at Duke with our Wilson Center for Science and Justice, looking at shot spotters piloting in Durham. And the Durham Police Department City Council did the right thing by saying, we want outside researchers to look at this before we decide whether we should be spending a lot of money to more long-term implement this software and acoustic platform in our city. And citizens are wondering whether this is a good idea. Well, we want to evaluate it and independently evaluate it, not just rely on the provider's own claims about its usefulness and reliability. And ultimately, after our evaluations, both looking at the data, did police responses improve in measurable ways, but also looking at qualitative data. A wonderful arts and sciences student led focus groups in town. The city council ultimately decided they didn't want to renew their contract and keep using it. That was their decision, but we were happy to share information with them as they made that decision. We did something similar looking at looking at quantitative data and surveying judges and lawyers, looking at the use of risk assessment in Virginia, which was rolled out by the Sentencing Commission to encourage diversion of lower risk felons, but there was real unevenness in judges' willingness to do that diversion, and we want to get a sense of why. Is this tool working? Are there disparities, including affecting vulnerable groups, and how it's being used? And so I do think that there's a lot of role that we can play when people in government are wondering, like, should we use this thing? Is it going to harm people's rights? Is it going to harm vulnerable communities? Is it worth the money? They may not be situated to study these things, and it really should be independent people, ideally academics, who are studying these AI or other software platforms, because you can't just rely on the developers say so. Of course they're going to say that their product is great and law enforcement should use it.
Sarah, what kind of changes are you seeing? Would you like to see, particularly in the courtroom?
I think overall there needs to be a leveling of the playing field with respect to resources and access to these technologies and the experts that are required to vet these technologies. We're losing attorneys in North Carolina. We need more court-appointed attorneys because there just aren't enough folks willing to do this work in the face of the voluminous discovery that they're faced with and the lack of resources that they have to challenge this evidence. Prosecutors and police departments, they have individuals who are specialized in digital evidence and these types of investigations. I'd like to see additional funding for support positions in public defender offices so that we would have our own investigators to help us with this digital evidence. And also a greater access for public defenders to things like transcription tools and other AI tools that could help us to more efficiently and effectively go through the voluminous discovery that we have because of the amount of surveillance that's being conducted. Brandon mentioned that there are some procedural protections that keep some of this evidence from being vetted in court, and that's in part a good thing that it's not coming in criminal trials, things like facial recognition and the software to compare firearms evidence. But the problem is those technologies are still being used to develop probable cause to arrest and detain and incarcerate our clients before reaching trial in a pretrial posture. And those escape review because the evidence isn't introduced at trial. And so I hope attorneys will continue to think creatively about how to challenge those types of evidence, even when they're not being introduced in the actual trial. And I'm seeing some progress in that area with additional Fourth Amendment challenges to those. I have a long wish list, but I guess to finish up, my last one would be just greater transparency from law enforcement as to when they're using these technologies. It's often buried. The evidence of what technology they've used to identify a client or do their investigation, they're often lacking in transparency when they apply for warrants to use these technologies. They'll say that they're using a PIN register, which I think is something from like the 70s to tap phone calls or something like that, when what they're doing is using a cell site simulator to track the actual location of a cell phone.
That goes to one of the reforms people in some states have said this, you need to have a warrant or you have to be corroborating at a probable cause hearing, but if there's vagueness about what's being used.
And judges don't know, what this term PIN register means, then there just needs to be more transparency so that a court can adequately review what's being asked of them.
So, Chaz, what are you thinking?
Yeah, so in thinking about opportunities in criminal law, I think about it along the lines that both Brandon and Sarah have been mentioning in terms of what we can do in court, but I also think about criminal law more broadly in terms of like our own work as like criminal law scholars, and then also sort of advocacy work geared towards, and even resistance, right? I think we can even think about opportunities in criminal law along the lines of providing opportunities for reflection, for contestation and resistance, right? I think in terms of reflection, and this ties back to the keynote presentation by Charlton, sort of what do we do with this body of work on critical race and digital studies, right? That pushes us to sort of recognize that technology is not neutral, that it's not fair, it's not efficient, but also, a big part of that is the notion to push back against sort of colorblind logics in technology. But when we think about criminal law, criminal procedure, right? And this ties back to your work, so I could throw this back at you, right? But
by all means,
these are sites where race norms are rife, right? So we're on top of that, we're talking about what do we do with these technologies vis-a-vis criminal law, criminal procedure. But criminal law, criminal procedure has, so many issues. And I think criminalization in the digital age is not like some new cultural shift, but sort of like an upgrade of the same. sort of philosophy. So what does it mean to know when we're thinking about predictive analytics and person-based, place-based predictive analytics that they're based on bias policing and data? What does it mean? Sarah mentioned ShotSpotter. What does it mean when we know that they are disproportionately, leaked, showed the maps that were leaked, showed the ShotSpotter locations in cities across the country disproportionately located in Black and brown communities? What does it mean when we know that criminal legal data is not just being captured but being produced? I think this provides opportunity for different, more bold and creative ways to contest this in court, some of which both Brandon and Sarah have mentioned. And so as both Brandon and Sarah was talking, I was thinking about a project that Jasmine Gonzalez-Rose at BU and my colleague Aziz Basin are working on and thinking about in terms of evidence. Like, how can we introduce anti-racist evidence, right? How do we bring in experts into the court that can testify, right? Like, what changes do we need to 702 to get these experts in to be able to talk about what is racist and what is not? I don't know. It's a big challenge, but I think it provides an opportunity for us to do so. I think it also provides an opportunity for us to resist in many ways. There's a huge body of scholarship developing in this space, and particularly in the context in which I'm talking about it, coming at it for the purposes of this panel, digital blackface and generative AI and the connections there. Many scholars are arguing that there are clear connections between generative AI and sort of like the approaches to eugenics, right? And some of this comes from colonial legacy. Wendy Chun, in her book, Discriminating Data, has argued that the emphasis placed on statistical methods, linear regression, and correlation in big data analytics driving AI have much in common with eugenics movement, right? She stresses that an investigation into the historical ties between big data and eugenics reveals that, quote, that the two are linked together by a fundamentally undisrupted view of the future, right? And most poignantly, she asks us, how did a worldview that did not believe learning could happen, that intelligence could only be bred, become the basis for machine learning, right? So what is this knowledge, which directions does this knowledge push us in terms of how we resist, how we conceptualize of the work that we're engaging in, and how do we even approach our understandings at the bedrock of both criminal law and criminal procedure? So things that I'm thinking about, it provides opportunities for us to shine a mirror back at ourselves, I think.
So I think it sort of in some ways builds on this, but I want to start with you, Sarah, on this question, just sort of thinking, like, what is the benefit of thinking about AI in the criminal context when we shift from thinking about the courtroom to just thinking about society more broadly? And I think in some ways Shaz's comment is sort of getting at that too, but I know that you have some experience in thinking about the ways that AI is impacting not just the criminal defendant, but also others in society as well. And I wonder if you can reflect a little bit on sort of examples of that and how we might begin to understand the impact of AI differently when we put that in the context of criminal law.
So I guess the concept I've been thinking about is it's not positive. It's I don't know. It speaks to the broader implications of this surveillance that's being conducted on individuals who are incarcerated and their family members. Jail calls are now recorded across the board, transcribed, entered into databases, and so information, including like voice prints, the addresses, the locations of the family members of anybody who's incarcerated, they're all being put into a database and tracked. And that information is being shared directly with law enforcement if law enforcement enters an agreement with these companies that provide communication for individuals who are in jail. And it's just, I think it's staggering. The amount of data that they're collecting, they're creating maps showing where family members and friends of incarcerated individuals are located within cities. And so to me, it speaks to a much larger problem, that it's not just, our clients who are incarcerated, who are being tracked and surveilled. It's their family members, friends, who haven't been convicted of any crime. They're just a loved one of somebody who's incarcerated.
So, Shaz, I'm going to come back to you for a moment. I mean, do you think that why should we think about AI from the context of criminal law? And I want to start with you in part because of how far your own research has spread, right? Starting by thinking about technologies in incarceration, but expanding out from there to thinking about, the new frontiers of digital blackface. Like, why do you think that criminal law is a particularly poignant space to get to those kinds of questions?
Yeah, it's a really good question. I mean, I think for two reasons at least, right? I think when you look at any sort of society or country, I mean, if you want to know where the most marginalized people are, you look to the jails and the prisons, right? And there in the jails and the prisons, you find the people who are overwhelmingly poor, overwhelmingly navigating mental health and behavioral disabilities, those who have been pushed to the margins of society. So I think when you're looking at how AI technologies are used within and related to the criminal justice system and generally criminalization, we can see the true values in tech development, right? And deployment. We can see sort of like the hidden philosophies driving the development. We can sort of deconstruct some of the assumptions that are apparent in design questions and decisions. And I think the other reason why thinking about it in the criminal context is so important, because oftentimes it is the criminal context that is the source of experimentation before it moves into other institutions and contexts, right? We see some of the technologies that are used in policing and corrections, of which Brandon and Sarah have been talking about, spill over into schools, right? Schools are using facial recognition technology, social media monitoring, and the like. You see this spill over into hospitals. You see this spill over into social welfare context, immigration, workplace, you can name it, and a number of these technologies were first deployed in the criminal legal context. So I think it makes sense as that to be a sort of a source where we're shining a light at.
So Brandon, last question, and then we'll open it up to the floor. I wonder so you mentioned that a lot of these technologies could be sort of more transparent, but it's a choice not to be, right? And that made me think about sort of the broad tension that arises because so many of these technologies are developed as proprietary, technologies by private companies in this public sector, and that is a sort of popular frame in which we begin to understand what's wrong with the technologies. And I just wonder if you could reflect a little bit on, I don't know, what do we do about the proprietary nature of technologies as in the criminal law context, and how does that connect to, I think in some ways, some of the questions or comments that Charlton was raising before about, who gets to choose? Like why, if it's a choice that we have these technologies that are, quote, black box, how can we begin to disincentivize those decisions?
Yeah, I mean, I think we would think it was like ridiculous if like your local police department said, we're going to replace our guns with a new form of force that we can use on people, but it's never been tested. We're just going to try it out. But we think it's actually more effective than traditional firearms. Like you wouldn't imagine, like, wait a minute, there's got to be some procurement rule that you can't just like use some new kind of firepower, like now we have a laser gun. And there has traditionally not been a lot of regulation of law enforcement procurement. And whereas, there are agencies that regulate medical devices, devices that consumers, rely on as to their safety, we have AI products that are being implemented in different settings that affect people's rights, and there hasn't been the kind of testing to see whether it works as advertised. And in any individual case, you don't know whether it's working as advertised because it's not interpretable. You don't know what factors it relied on and with what weights. When researchers have gotten their hands on some of these tools, they've found that they don't perform as advertised, and actually what they do can be boiled down often to something quite simple that could fit like on an index card where you see what weight it gave to the person's age or to their prior convictions. And sometimes it's modestly useful, and you could use it and get at least some information from it, and you'd have a sense of whether it's accurate in a particular case by looking at that index card and saying, oh, they identify this person as low risk because they don't have any priors. Well, that's true. Or, actually this facial recognition match is not that reliable because it's relying on an old photo where the person didn't have like the big goatee that they have now. But again, it's a choice to not require developers to provide interpretable models. And there's been a sort of a myth that Cynthia Rudin in our computer science department and I have tried to debunk. A lot of the developers say, well, actually, like the secret sauce here, the reason it performs so well is we just let the machine do the learning. Just like, computers can beat people at Go and chess, like they can identify patterns that no human mind could understand. And so you lose that performance edge if you try to reduce these to like old-fashioned math, simple regression, simple algorithms. But what Cynthia colleagues have shown time and time again, with the kind of data that we have in the criminal system, which is data that you can put like in a spreadsheet, rows, columns, tabular data, it has never been shown that there's actually a performance advantage to letting the machine roam free, that you can distill those models. Even if you let the machine identify the patterns, you can then distill those patterns into something that's very easy to write down and have the lawyers, the judges look at and understand, which is what we need if we're going to use this stuff in court. And so really the burden should be on the developer to articulate why they are gaining something that can't be interpretable, why they're providing something extra that we can't understand in court. But they're never asked to justify that typically, and there is no regulation anywhere that has said, oh, if you're going to use it in court, it's got to be interpretable. There's no regulation anywhere that has said, oh, by the way, if you're going to use this in court, there has to be independent testing, like in actual science, where other scientists need to be able to replicate, reproduce your results. Instead, it's we've let the developers sort of get away with, well, we've developed this model, it's really cool, just try it out. Hopefully that's starting to change. There has been more talk, especially in high-risk areas, of requiring more vetting of these projects. But even in many of those contexts, the vetting has been, well, the developer should report on their risk assessment or their auditing in-house of these tools. We would never say like, oh, put the drug on the market and just do some trials in-house and don't allow any other researchers to see if they can replicate it. That's what we need in this setting, just like in any basic science setting where you don't trust a scientist's word that they've made a discovery. You need to actually see the data replicated. So hopefully that will start to happen. And maybe there will be useful tools that are proven to be useful based on testing that would ideally safeguard people's rights, improve public safety. That could be good. Like science can lead to progress, but it has to actually be science and not just the say-so of someone who says they have a toy that we should play with.
Can I add something to that?
Yeah, please.
I think that's really, really interesting, and it makes me think about how we're at a point now where because there's lack of movement at the national level, you have a bunch of states that are passing data privacy legislation, and I think we're at least like 20 states with data privacy. Consumer privacy bills on the books, and in the next year or two will probably be over half of the states. And when you look at all of those, and this sort of speaks to the point that you're making, Brandon, is that in every single bill you look at, whether it's the draft ones or the ones that have been passed, there always are carve-outs for law enforcement purposes. So you don't get the requirements that are being given in other contexts are always subject to exception, clearly, explicitly stated in the laws when it comes to law enforcement purposes. So,
All right, let's open it to the floor. Any questions? Tim.
Yeah, thank you so much for the presentation. I learned a lot. Some people who are deeply concerned with mass incarceration have looked to AI to provide sort of fairer results, let's say in the criminal sense. The idea is that even if the tools are perfect, they can be perfected, we can get to a more egalitarian society. I'm just kind of interested in the democratic implications of that type of project. And in particular, the implications of having more tech corporations in that space making decisions about the political process, right? So on one hand, judges can receive, let's say, better risk scores, or we can, judges can be fairer as they're using these risk scores. On the other hand, there's just this kind of larger concern that corporations are making decisions, often not regulated through the sort of traditional political channels. And they are having an outsized role compared to, let's say, ordinary citizens in the political process. I'm really interested in how people in your space, I don't write in this space, but how are they thinking about these kinds of questions about democratic process and then the democratic cost and benefits of having more corporations in this space, even if they can provide a fairer product?
I planted that question.
Sure. I guess to say a couple things, like, there can be, even just to understand the scope of mass incarceration, it's not bad at all to look at data, to study it, to be studying and documenting disparities in the system. So, being data informed is not a bad thing when you're trying to understand the scope of things that are going wrong in criminal justice. But understanding data and being critical of it is different than saying we need to use AI tools. There hasn't been any evidence in any particular context that an AI tool actually helps you make criminal justice decisions better than simple tools, which may be data informed. It's absolutely the case that we have seen people use their discretion in ways that are incredibly correlated with race. Human decision makers can be biased, and that's part of the challenge of being human. And giving people objective evidence-based tools can be a good thing if we vet those tools, but you can't do that if it's a black box AI system. There's just no way to know whether it's informing human discretion in a sound way. But there's also no evidence that any such tool has been developed. So I don't think there's any danger of a corporation coming in and saying we have the solution to some particular criminal justice problem. Some of them may claim it, but there's no evidence that any AI type tool works. And actually, some of the companies that were marketing some AI tools have sort of stepped away from the claims because some researchers were able to get their hands on data and raise questions about some of those tools. But ideally, what you would have, given the stakes in our criminal system, is if we're going to rely on science, it should be actual robust science.
Another question?
I would add to that, Tim. Thank you for the question. I think at the core of democracy is like a robust conception of like accountability, right? Accountability of the state to the people, right? And the way that people are thinking about it in the critical tech and law space is sort of investigating what it means to be able to hold the state that is becoming increasingly datafied accountable, right? When it's the big tech companies that are acting as sort of like the puppeteers to the state in many ways, right? There's a piece that was written a few years ago called "Learning Like a State," right? And these researchers sort of investigate how states are investing deeper and deeper into like using data and datafication processes, right? And one of the things that they argue and they see is that states increasingly become less accountable for the outputs, whether it be sort of digitized or algorithmic processes and social welfare resources distributions. And you can think of a whole host of other governmental institutions where data logics are being incorporated, right? And I think one of the biggest, if you think about democratic costs, is that ability to be able to hold someone accountable. We don't even know how decisions are even being made, right? Who are making these decisions? How can we get a hold of them? Many of these tech companies are not only not accountable domestically, they're not even accountable like globally in the ways that they operate. I know Afoma earlier was talking about what was happening in Kenya in terms of like, content moderation. But what these tech companies are doing is they're getting in on the ground floor and influencing potential steps towards regulation. I mean, Sam Altman at the head of OpenAI was quite like open in his actions, right? Really challenging the EU to ensure that there isn't heavy regulation of AI, or we're gonna pull out ChatGPT from the people in the EU, right? Literally threatening to do that. In terms of even the state privacy bills that I mentioned that are being developed, you're having tech companies get in on the ground floor. It's a problem when a data privacy bill like Virginia is championed by like Meta, right? We're thinking of it as data privacy bills and this effort in the 21st century as we're becoming more digitized, that this is a floor upon which we can build more robust protections when it comes to big companies. And no, they're getting in on the ground floor to make sure that it's a ceiling, right? That we don't go beyond this minimum threshold. So I would say accountability is sort of like the big crisis focus point in this area that people are struggling and wrestle with. How do we make the state more accountable when it's captured by big tech?
Other questions?
Well, I do. Wait, we're not going to stop yet. I got more questions. Sorry, I thought somebody was going to have one. So, Shaz, I wonder if you could talk a little bit about, and actually this is for all the panelists, talking a little bit about data, right? So not the technology, but specifically thinking about the challenges of data and what we know in the criminal context about where this data is coming from. So I guess, Shaz, I know you've done some work on, data as new cotton, and I'd love to hear you sort of reflect on that in relation to data production in criminal law. But I really open that up to the entire panel of sort of reflecting on, I think it was Rashida Richardson says, criminal law produces dirty data, and uniquely so dirty data. And so, how can we understand and begin to address sort of the challenges of dirty data as we see, AI proliferating?
Yeah, I mean, I would like to hear you respond to that too, because as you asked that, I immediately think about the comment that you made earlier in the day about, I think you were talking about, was it Spotify and recommendations, right? I sort of think about data as being a vehicle of control and dominance, right? So to sort of keep particularly racialized, racially marginalized communities within the racial hierarchy status quo, right? And that's pretty much why I'm talking about digital blackface, because what data is being used for, data is being used to sort of continue the production of race, right? I talked about blackface, right, as producing, as engaged in the production of blackness, but blackface was also the production of whiteness, right? The main folks engaged in blackface was like working class whites, and it was used as a form of sort of creating white integrity and solidarity through sort of using the black body in this way. Black body becomes a vehicle in the same way that data is a vehicle. And I went to this really good symposium earlier this year talking about the connections between racialized bodies and data and how they're used in ways to make these larger statements. So when I think about data in that way, that's what I think about as sort of a new tool to reproduce the old.
Mm-hmm. Reflections on dirty data.
I think I would just be very skeptical of any predictive tool that's built upon carceral data. Just speaking on the day-to-day public defender practical level, I know that the clients that we represent are our clients because they're being policed more, they're being surveilled more, they're being surveilled more because of a prior conviction. They have a lack of opportunities because of a prior conviction. It's a system that feeds itself. And so the predictive value of any data from the carceral system, I think, has bias baked into it. And so the development of any algorithm to predict whether somebody's going to reoffend, in my understanding, it's largely based on their criminal record. And to me, you can't separate a criminal record from bias.
I'm guessing you've also seen plenty of the time errors in your own client's information. And that's pervasive. I mean, a lot of the work we do at the Wilson Center, we're looking at these different administrative data sets. And it's not like it's the job of like the sheriff's staffer that's booking people at the jail to make sure someone's information is right. And when you have clients in distress being arrested for the first or the 10th time, it's not like they're trying really hard to make, oh, wait a minute, like this is my current address, or what's on my driver's license actually, like that's not my age. Or I mean, we'll see people's, their race, their age, their address entered multiple different ways. It takes a lot of work actually to see, even for the people that are selectively policed and have criminal history, connecting that and making sure, is that really the same person? Who are these actually 3 different cases entered in duplicate by mistake on the same day, or is this actually 3 different arrests? Or and so it's not data that anyone was trying to produce for research or to develop a useful tool. It's it's not like here at a university we're trying to actually enter our students' grades correctly, and they can see their grade and correct it if it's wrong. Like no one can see all these records and say, you know what, like you actually got my age 3 different ways, and I don't want you to do that because I actually would like you to correct my criminal history because I don't want some officer to think that I have felonies when I don't. Accuracy of expungements if those occur, all kinds of problems with this data, and you can't correct these errors very easily, if at all. And if you have a tool that's relying on this data, you can't correct the errors in the way that it's relying on data in your case. If it's uninterpretable, you don't know what the tool did. So there are all kinds of problems with the data and serious misuse. At the same time, there is no data. Like no one is even trying poorly to collect data on really important topics in the criminal legal system. And so, some of our work has been to encourage prosecutors and public defenders to document some of the reasoning that goes into pleas. But that negotiation, on the defense side, there are some client protective reasons why the reasons involve client confidences and the like. And on the prosecution side, there's public reasoning, the public interest. Why did we offer this plea or that plea? That system those decisions are often not documented. All you see in court is that pleas were agreed upon between the parties. Lots of different discretion that is simply not documented. In many jurisdictions, like very important things that happen in court are not recorded. Certainly, like a judgment is recorded, a plea or a trial, but bail decision making, it's not like you have written Supreme Court opinions or written anything in most jurisdictions. Those hearings may not be recorded, transcribed, easily accessible to the public. A lot of important decisions are made without any record and without any data generated. And so you possibly have a tool that would improve that decision making if there's no information about it. And it would be good to have data on some of those things so that we would know if there's bias and if there are errors, but we don't have it.
And so AI court watchers.
AI court watchers. Well, you have to actually have someone in court. And actually, often these types of informal hearings, there isn't really good audio. You can't really tell what's going on. Can't hear people's names. And so there are all kinds of problems just with public access to really meaningful decisions. And on the flip side, you have this data gathering and mining, like what's happening with all of our prison calls in Maryland, North Carolina, that is also not public, and we don't know what's in that data or what's being done with it. So we have troubling overuse of data, troubling erroneous, error-ridden data, and then just lack of information about really important things that affect people's lives. So we have a little bit of everything in the criminal legal system.
We do, don't we? So much of your work, Brandon, has actually been calling for more data, even before sort of the like hot new wave of like big data and evidence-based practices were sort of mainstream. I just wonder, do you feel that when you call for different kinds of collections of data now, is it different? Like, is it like, do people receive like sort of calls for more data today differently than they did perhaps like 10 years ago?
I think it's never easy to, one, I guess, good thing that sort of is a protection against AI in court and in the criminal system is that there's some decisions which ultimately do have to be made by people. We have jury trial rights. We have rights to have a judge decide things because of due process and other protections. With some consumer products and the like, you can't get a person on the line. We have the opposite problem. We have police on the streets, we have bail magistrates, we have judges, we have a lot of people whose job it is to process arrests, process convictions. But we do have people. The challenge is that these aren't data collectors and they don't want to spend more of their limited bandwidth collecting information. And that said, there is a desire, like plenty of people increasingly are, they hear public concerns about how are we making these bail decisions? Like, how am I supposed to know? Like, I'm not a data scientist. Like, how am I supposed to know whether this person poses a danger? Like, I know what they're arrested for, and I know what the public defender tells me, what the prosecutor tells me. Like, I would like to know something else if you can tell me something else. And there are more prosecutors who say, like, we're open to progressive ideas if they could inform our work. Like what should we negotiate with our pleas? Like, we don't know. We just have like going rates and sort of lore in our office. But if you can tell us something, research informed, that would be good. We're open to hearing it. And so I feel like, there is more receptivity because there's a growing body of research. And there are some areas where research really has impacted criminal law and evidence in good ways. Like one example is in the field of eyewitness memory, where there's just much more understanding now that eyewitness memory is really fragile, that you can have wrongful convictions because people can be very easily fall prey to suggestion and identify innocent people unintentionally. Like that body of research has really impacted policing. It took like 3 decades, but it happened slowly. And so there are some success stories where good science helped to change the way people think about stuff that they had never really thought about before in law enforcement. But it can take a long time for science to make its way into the justice system. And then again, like maybe that does protect us from AI in some ways, that we do have people who we're entitled to make these decisions. You're entitled to a human public defender. There will be a human prosecutor that's supposed to represent the interests of the public. And that is important. There are some countries where they've even piloted sort of automated forms of judging that would run into real constitutional problems in this country, and that is a good thing.
Margaret?
Okay. So I wanted to follow up on your idea of needing more testing for the validity and the scientific establishment of the efficacy of these systems, these AI systems, and wondering whether or not, short of some kind of statutory requirement, could we see a new conceptualization of the Confrontation Clause under the Sixth Amendment? Do you think we need a new amendment to the Constitution? Do you think that possibly we need just a revisioning of Daubert Frye? Or what do you see as the best way forward?
I mean, Rule 702 was just amended to emphasize the Daubert obligations of judges in criminal cases. I mean, I do think the existing rules are very good, and we just need judges to take them seriously, that it's not enough for an expert to say, just, I'm an expert because I am, and similarly, like, I'm an expert because I have an AI tool, and it's good. Like, that should never be enough. Judges, it's like not surprising to Sarah that judges are often more skeptical when it's the defense that says, I'm an expert and I have an AI tool. The case that I mentioned where the judge excluded software that enhanced video, whether it was AI or not, we don't really know. it was a defense expert. And so the judge excluded a defense expert. Well, we've seen experts excluded in the area of fingerprint work. It's almost always defense experts where the judges are skeptical and are wondering whether this is really good science. And so, we don't see these reliability rules applied the same way when it's a vulnerable defendant as opposed to the state, which has more resources. But the rules are good. They do ask that a series of questions be asked about the reliability of methods, the reliability of how the methods were applied. Like, those are all the right questions to be asking about any kind of science being used in court. But we do have a history of those standards not being applied well in criminal cases. That back to the 2009 National Academy report that led to the creation of Sarah's job. Like, that report said, like, Daubert is good on the books, but judges simply they've not applied it in criminal cases. And that's what the advisory committee said when they revised Rule 702 last year. They said, we're in some ways just reaffirming what was always the law, which is that you actually have to examine reliability if evidence is going to be used in court, and particularly in criminal cases, given the stakes. And so it's not about changing the standard. It was a very good standard. We were underscoring the obligations of judges, which they have been neglecting.
Oh, go ahead.
So some of these local jurisdictions have been banning facial recognition technology, and wondering whether or not you think that is the direction that we need to go in to inform and improve the equities in criminal justice proceedings, but also chat specifically to your observation about Ruby Chung's work and the eugenics implications. The facial recognition technology companies that now say that they can predict criminality and terroristic intent based on the integration of both the biometric systems as well as an aggregation and analysis of other private and public databases, and whether or not that moves us closer to that issue of embedding a eugenics philosophy in these technologies.
You want to respond first?
Okay. I think with respect to the facial recognition technology, until there's more information about it, I don't think it's ready for prime time. I don't think that individuals should be arrested based on a technology that we just don't know how effective it is, how reliable it is. I also think there could easily be misunderstandings in how it should be used. Clearview AI, probably the largest facial recognition tool, I mean, they train police officers that they're not supposed to make arrests based on a facial recognition, that there has to be more investigation, that there has to be a human who's trained in facial recognition to verify what they've ranked as the best match. I don't know that that's happening in practice. And so I guess without more study and without more regulation, I don't think we know enough about the reliability to be using it.
Yeah, back to standard criminal data, like the human examiner can flip over the picture and see the person's criminal history and say that, oh, this is what Clearview AI recommended as the most likely match to a robbery. And look, candidate number 4 has prior robbery arrests right here in Durham. Perfect. Right there, it's not the human examiner has all kinds of outside biasing information, and just built into the way these systems work.
And I know we only have 30 seconds, so the short answer to your question is yes. But yeah, so I mean, and I'll just end with one of my biggest concerns and what we see in the context of AI is specifically biometrics, AI and biometrics and biotechnologies at University of Maryland, surrounded by a huge biotechnology campus that's like, nationally AI recognized center. But it's sort of the normalizing or the reemergence of race-based science and sort of the normalizing of race in both law and technology, right? Which is kind of strange because it's sort of like both the invisibilizing of race, but also sort of like the entrenchment of race. And I think as critical scholars, we walk this tightrope where we recognize that many of the civil rights legislations and laws have been used to sort of codify the notion of race in regulations governing biotechnology and biometrics. And on the one hand, we push back against colorblind logics as critical race theorists. But on the other hand, we want it recognized in some instances, right? I think we're walking a fine line, and AI technologies, when it comes to biometrics and biotechnologies, are pushing us in ways where the social construct of race is given validity in ways that has no biological justification whatsoever. So it's an interesting intersection there, and I don't quite know what to do with it.
With that, we thank this panel for your insights and for your knowledge and expertise, and especially in this area that affects